In this video, I want to go briefly through kind of 5 common mistakes I tend to see from law students when answering problem questions. And this may be a problem question in the form of a summative assessment or a problem question that's done under exam conditions and you have time constraints. I think the advice in this video is applicable to either of those scenarios. I think it's also applicable across legal subjects, because once you nail problem question technique, you can apply it to lots of different subjects. So although I'm using public law examples in this video because I teach public law, it's the area that I'm most familiar with, nevertheless, I think the things that I mention are techniques that you can apply to other areas too. So what I would say is maybe don't be too concerned about the law in this question or your knowledge or understanding of the law. Rather look at how it's being used and the key things that I'm picking up. So just a brief recap in terms of problem question technique. We should be familiar by now with what's known as the IRAC, ILAC, ISAC method, depending upon what you've been taught in your class. But generally, we tend to approach problem questions through these 4 different stages. The first stage is we're going through the problem question and we're looking for the various issues. What are the key issues? And then for each issue, we're doing an analysis of the relevant law, applying the law to the facts at hand, and coming to a conclusion. Now, for this reason, a problem question tends to be made up of multiple different issues. Rather than think of it as a problem question, we could think of it as a problems question, because there's multiple little problems within that question. And so the first thing is the issue. What is the key legal question that is being raised by the facts of this problem? The next is a relevant rule or law. And this is sometimes you will see it referred to as IRAC or ILAC, depending upon whether people use rule or law. I also like to include this notion of reasoning, because I think that gets to the key as to what we're looking for. Is that we're maybe not just looking for law cases, and that would be one of the mistakes that I deal with in greater detail, but the reasoning underpinning that case, the ratio of the case, and it's the application of that to the facts at hand that's key. So sometimes by thinking of it in terms of reasoning in a case as distinct from just the law, it's the reasoning underpinning it, that can be helpful and useful for when we come along to actually applying this law to the facts at hand, which is our next stage. Okay, taking that existing law and applying it to the facts of the problem question to analyze that and come up with our solution, or coming up with our conclusion as to that relevant issue or that relevant problem. So those are the 4 steps, and we should be doing these for each and every issue that is raised by the problem question. Again, think of it in terms of there usually will be multiple problems within a problem question. And I think the first mistake that students often make is that they miss some of the key issues, or they might misidentify an issue. So by misidentify, I mean they deal with it under one type of law when perhaps they might have been better dealing with it under a different type of law, or to deal with one issue when maybe they should have dealt with it under another issue. So I have a rough example here of a problem question that I've kind of quickly drafted. Now, just caveat here is that normally our problem questions, when we submit them for you guys for tests, they tend to, they're going to be internally scrutinized, and then they're going to go to an external examiner as well for scrutiny. So this rough draft here has not gone through that process, so there might be some mistakes involved in that, but rather the point really is just to kind of focus on maybe how to identify issues and what are the key things that we're looking for. So I've drafted this. We have this fictitious Anti-Extremism Act, and it empowers the Culture Secretary to issue licenses for gallery displays, film screenings, and theatrical performances. The minister therefore has the power to refuse a license if they believe that the material or performance advocates for extremist political views that undermine British democracy. And Mary applies for a license for her paintings and Mary's paintings are abstract. They consist of amorphous shapes and paint splatters. And then the minister refuses the license and he states in a letter to Mary that these paintings make no sense to me. They make no sense to anybody. There must be some immoral message in these paintings that could corrupt the youth of today. Otherwise, why make them? This message must be particularly immoral, given the lengths to which you have gone to in order to hide it. And then our instructions is to advise Mary whether she can challenge the decision of the culture secretary by way of judicial review. So what are the kind of relevant, maybe public law grounds that this question has raised? So first thing we need to look at is the problem question is, why have I included this information? Why have I drafted a problem question to include certain types of material? And so the first part of this then is essentially the power that the minister has. This is the law, and this is the power that they have. And then this, obviously the next important bit is the reasons given by the minister as to why he has refused the license. The second part about Mary's description of her paintings. Again, we need to think about, why have I included that information? And I always think actually a good practice for students in terms of problem questions is obviously practicing answering them is important. But I think a good exercise to give yourself would be to try and draft a problem question. Try and think of a way in which, let's say you want to draft a problem question that addresses 3 different issues or 3 different grounds, and to try and come up with facts to stress test the law in this area. And if you practice doing that, you'll see that actually that might be helpful for you to identify patterns in the problem questions that academics draft for you. So coming down to an analysis of this problem question, what are the kind of grounds that we might be looking for? So again, we're looking for things that, the power is the power to refuse a license, if the material or performance advocates for extremist political views that undermine British democracy. And I've highlighted here in the problem question, well, actually the minister seems to be talking about things that are immoral. And he emphasizes this notion of morality twice and refusing it on the grounds that it's immoral. Is immorality the same as political views? That might be something that we want to discuss. And I think the most obvious ground here to look at would be Article 10 on freedom of expression. Now, depending upon where you do the subject, and I have taught at previous institutions where we design problem questions that clearly separate the Human Rights Act from maybe classic grounds of administrative law. And this is why the advice section, where it says advise in relation to judicial review, if you've been a problem question might be drafted in such a way that says maybe focus only on the Human Rights Act or focus only on classic grounds of judicial review and exclude the Human Rights Act. This question hasn't done that. So basically, by me not doing that, I'm inviting my students to actually examine all possible public law grounds, human rights and judicial review. So the first one I'm thinking straightforward is Article 10, freedom of expression. And we work through our case law on Article 10. Is art a form of expression, a type of expression protected by Article 10? Yes, it is. What is the legitimate aim? Is there an interference? I think there very clearly is an interference. Refusal of a license. Is that prior restraint? Yes. Is it prescribed by law? And then we go through our test: proportionality, necessary in a democratic society, proportionality, freedom, is it artistic expression or political expression, etc., etc. So you'd work through the Article 10, and that would be one potential ground. But there might also be another ground here. Maybe we could also look at it in terms of classic illegality. Essentially, has the minister exercised a power here for an improper purpose? Have they done it for something that they're not supposed to do? For example, have they, they were only empowered to ban political extremism, but they've done it on the grounds of immorality. Could that be a possible ground that we could explore? And maybe by not doing that, we might have missed some points here. Has the minister taken into account an irrelevant consideration, perhaps by taking into account the morality? That might be another thing that we can look at. And actually, if you look at the case law on improper purpose and relevant or irrelevant consideration, there's very often an overlap between the two. And it can be difficult to maybe categorize which one or the other. But the point is just to note that, the facts of this question aren't exclusively exhausted by Article 10. There might be other grounds, and because I've drafted the question to say advise her by way of judicial review, only focusing on Article 10, you could do an excellent job of that. That's great. But maybe you're missing a trick here by maybe not talking about the other things like illegality. And then even irrationality. The minister basically taking an abstract view, or taking abstract paintings and saying, oh, there must be something politically immoral about this, about abstract art. Is that irrational? Could we throw the grounds of irrationality at this as well? So just be aware. There might be other issues at play, and just because you're doing it on one issue, don't forget that there may be other things at play here as well. So does that mean then that you should maybe throw all possible grounds at a question and hope something sticks? And essentially, I would say absolutely not. No. Because this would essentially demonstrate a poor inability to identify the relevant issues. It doesn't show that you necessarily understand the law. You're just hoping that something would stick. And that can be problematic. That's not showing your ability to identify the relevant issue. Rather, what I would suggest you do is that you think carefully about what you think are the strongest or clearest grounds. And then you spend your time on these strongest grounds, and you spend most of your word count on these strongest grounds. So in that previous example, Article 10 is a really, really strong ground, and I would spend quite a lot of my word count unpacking Article 10 and all those different stages. Then my discussion perhaps of illegality and improper purpose would be shorter. Likewise, irrationality would be shorter. I'm spending most of my time on Article 10. So don't just try and throw every single thing at it in the hope that something sticks. Likewise, you need to think carefully about the order in which you approach these grounds. Again, putting your strongest foot forward first. Starting with Article 10 or irrationality. Well, irrationality, I like to think of it, it's a long shot. As the Americans would say, it's a Hail Mary throw. You're throwing it and you're hoping that it will stick. But it's a really difficult ground to prove. And so you don't start off with your weakest foot. You leave irrationality to the end. Okay, and that order then in which you're doing these grounds does actually demonstrate that you have a good understanding of the law in the area. And so again, take a little bit of time before launching into a problem question to plan things out. I know we might want to rush and start straight away as soon as we get the exam paper in front of us, but maybe it's helpful to take a little bit of time. The second thing, a mistake that students often make, is that they spend too much time on unproblematic issues. So, for example, in that previous example that I gave there of the Anti-Extremism Act that empowers the Culture Secretary to issue licenses. Now, amenability, whether a decision is amenable to judicial review, is a possible issue. That is an important factor that we look at in judicial review. But whether the decision of the Culture Secretary in this instance is amenable to judicial review, that's not really an issue here. That's very clear forward. The legislation is giving a minister a power. It's fairly straightforward that that's amenable to judicial review. So you don't need to waste time on it. And there's no point wasting a lot of word count exploring this, or maybe the definition of a public authority under Section 6. They're very clearly a public authority under Section 6. So I would not waste my word count on those kind of issues. Instead, if a student is spending a lot of word count on these things, like whether they have whether it's amenable to judicial review, whether Mary has standing under public law, or whether Mary is a victim under the Human Rights Act, Again, that's fairly straightforward. And if you waste your word count on those straightforward issues that aren't controversial, well, that reads to me like filler. It reads to me like you're trying to get points for unproblematic issues. And then if you've not executed the rest of the essay or the rest of the problem question as well, then it's going to say to me, well, look, you're just trying to fill up space here. So be careful with spending too much on. You can absolutely mention it in a sentence or two if it's not if it's relatively straightforward, but don't waste too much word time on it. The third mistake I think students often make is accuracy with the law. And this takes the form, I think, of students using maybe broad kind of generic statements that aren't accurate in terms of what the law actually says. So here's an example, say fictitious quote that I've constructed, but you can totally see this in a problem question. The Human Rights Act, or even in an essay question actually, the Human Rights Act 1998 enables courts to interpret legislation compatibly with convention rights. Yeah, it does. But what specific part of the Human Rights Act? We're looking for, specific legislative provisions. We're lawyers, we're supposed to be accurate. So we're looking for Section 3 of the Human Rights Act. And what does it actually say? Enables the court to interpret legislation compatibly. That's kind of vague phrasing. The actual phrasing is that it's so far as it is possible to do so, legislation must. So it's not that it enables courts, it requires courts. Courts must interpret legislation compatibly, but only so far as it is possible to do so. So this initial quote is quite vague in terms of what the relevant law actually is. I think a second example, and again this is something that's quite common in problem questions. In Ex parte Coughlin, the Court of Appeal found that a promise had been made to a disabled person that their place of residence would be their home for life, gave rise to a legitimate expectation. This is correct. However, is it a procedural legitimate expectation or a substantive legitimate expectation? The key thing in Coughlin actually is that it gives rise to a substantive legitimate expectation. Essentially, not just that they had an expectation that a certain procedure would be followed, that they could engage with a procedure, but rather that the outcome would be followed, that they would have a home for life. And this distinction is really important because the substantive legitimate expectation is much harder to prove because it's requiring the court to basically, say that the public authority should have made the decision that led to this outcome, or should have enforced and ensured that outcome, which can be a controversial thing for a court to do because they're stepping on the toes of the original decision maker. So the difference between the two is really, really important. And just saying legitimate expectation rather than substantive legitimate expectation is inaccurate. We're looking for more accuracy. The fourth mistake, and I think, if I could give one example, one key mistake, I think this is the key mistake that students do in problem question. And it's where they compare facts with facts rather than applying the law to the facts at hand. So what do I mean by this? It's where students see a problem question and they see that the facts of the problem question are similar to the facts of a case that they've read or a case that they've covered in class. And therefore, they basically say, well, these facts are the same, and so the outcome is the same. So here's an example. Again, this is a problem question that I've kind of just drafted. It's not gone through the normal checks. But essentially, here we go. Section 1 of the Weekend Entertainment Act enables local authorities to permit entertainment businesses in their area to open at the weekend, subject to such conditions as the authority thinks fit to impose. Springfield Council has granted a license to the Springfield Musical Theatre to open on Sundays, provided that no children under 17 were admitted to Sunday performances. The council stated that the reason for this was because of a recent rise in acts of vandalism that it claims can be attributed to the large number of teenagers loitering around the city centre at weekends. Advised Springfield Musical Theatre on whether they can challenge the conditions of their licence on the basis that Springfield Council acted irrationally. Now, hopefully, if you're a public law student, you should realise the facts of this case are very, very similar to the facts of Wednesbury, Associated Picture Houses versus Wednesbury, where we got the Wednesbury unreasonableness rulings come down from. So, this might be something that a student would write when they're doing the comparing facts with facts. The facts of this case are similar to Associate Provincial Picture Houses versus Wednesbury. In that case, the Court of Appeal found that a decision by the local council to only allow a cinema to open on Sundays on the condition that no under 15s were permitted was not unreasonable. Following this case, I would advise Springfield Musical Theatre that any challenge based on reasonableness, irrationality is likely to fail. Okay. What is the problem with this? The problem with this is that there's absolutely no explanation as to what the reasoning in Wednesbury is. There's no understanding of the ratio of the rule or of the test of unreasonableness that's set out in Wednesbury. So here is actually the test. Here's the statement in Wednesbury that's key. It's true to say that if a decision on a competent matter is so unreasonable that no authority could ever come to it, then the courts can interfere. So that's the test. So unreasonable that no reasonable authority could ever have come to it. However, then they come along, but to prove a case of this kind would require something overwhelming, and in this case, the facts do not come anywhere near that kind. So it's that ratio, that test that we're looking to be applied. Not just say, this is the same as Wednesbury, so the outcomes being the same. The student's paragraph here doesn't give any reflection or understanding of what the ratio in Wednesbury actually was, and then it makes no real attempt to apply that ratio to the facts at hand. So it also might be important to think about whether the law has moved on since Wednesbury. Have we got other restatements of the law, other restatements of this unreasonable test, i.e. irrationality? Okay, so by just doing that, comparing facts with facts, we're maybe missing out on subsequent developments in the law and subsequent cases that we can possibly refer to. So how can we avoid this applying law to facts? Comparing facts with facts. How do we actually apply law to facts? So I have this sample here then. So the facts of this case, it's similar to Wednesbury. So we're starting off very similar to that previous answer. But then we're moving on to actually explain what was decided. There the Court of Appeal stated that no reasonable authority could ever come to it. A decision so unreasonable. And we're also explaining the reasoning behind it. This test is strict as Lord Green's main concern was to constrain the role of the court, emphasising that it is not the court's task to retake Merit's decision that the decision maker is empowered to take. Judicial review, it's not an appeal. It's not about asking the court whether they would have decided the case the same way. It's not about putting the courts in the same shoes as the original decision maker. It's about whether the original decision maker acted unlawfully or not. And that's the issue with irrationality, is it potentially blurs this distinction between review and appeal, and that's why the test is strict. And so by including that little clause there, we're demonstrating our understanding of why the test is so strict. Then we move on. Subsequently, in the GCHQ case, Lord Diplock restated the Wednesbury unreasonable test as applying to a decision which is so outrageous in its defiance of logic, of acceptable moral standards, that no sensible person who had applied his mind to the question to be decided could have arrived at it. So we've a restatement then of a more recent case as the test as to irrationality. So there's our statement as to the law. Then when we're applying at it, As the threshold of irrationality is very high, Springfield Musical Theatre may have a difficulty in challenging the conditions of their license. It would be difficult for a court which lacks expertise on the issue of vandalism in Springfield to find that the council's restrictions are so outrageous in its defiance of logic. So you can see we're referring it back to the facts at hand. We're applying that law and embedding the law in our analysis, emphasizing maybe that the court doesn't have expertise that the local council might have in terms of vandalism. So trying to make that distinction between review and appeal come through. On the contrary, there is some logic to the idea that reducing the number of teenagers in the town centre could reduce vandalism. So then we're suggesting there might be some logic. And then we're emphasizing while there might be some moral objection to treating young people differently to others, this does happen in lots of other areas of life, so it may be difficult to contend that this decision is defiance of acceptable moral standards too. Now note when I've drafted that problem question, I emphasize on can they challenge the decision on the ground that it is irrational. So I limited the grounds to irrationality. There might be some human rights grounds that you could possibly bring in on this case, but I've defined the problem question in such a way as to limit solely on irrationality. So hopefully in this way then you can see how I've not just said this case is similar to Wednesbury. I've actually identified what the ratio of Wednesbury is, the reasoning why the threshold is set so high. I've brought in some more recent case law in terms of GCHQ, and then we've applied it to the facts at hand. And in that way then we're avoiding doing the comparing the facts with the facts. We're actually demonstrating our understanding of the law. And then I'm reaching my conclusion. I would therefore advise that Springfield Theatre may have a difficult task in challenging their license conditions by way of judicial review. Actually, I should probably put in there on the grounds of irrationality, because we've limited the problem question there on the terms of in grounds of irrationality. Now, the final mistake that students make, I think, is that some students assume that their client has to win. And this often happens where a student advises their client that they have a strong case, even if they don't. So this can arise as a result of the student misrepresenting the law or misapplying the law to the facts at hand, and maybe reaching a conclusion that is completely at odds with the case law. And I think, this can sometimes happen when students confuse advising on a problem question with mooting. So when you're mooting, you're engaging in an adversarial process whereby, you're only putting forward your client's case. You're responding then to the respondent's case and potentially trying to rebut that. And you're doing it kind of in a mock court setting. But you only have to put your client's case forward. That's what the adversarial process is like. But advice in a problem question is different. Advice in a problem question doesn't take place in this setting. You can almost think of it as someone coming into your office and asking you whether they have a case and whether they should take a case. And so you have to weigh up the problem from all different perspectives to think about what's your client's likelihood of success. And ultimately you're advising a client on whether they should undertake very, very costly legal proceedings. And very often the best advice that you can actually give a person is to let it go and to tell them that they don't have a strong case. So don't think that simply because you've been asked to advise X, that X has to win. Absolutely not. Very often X doesn't have a case, and if they don't have a case, you should tell them, and you're going to be saving them quite a lot of money if you do so. So those are 5 kind of common mistakes that I see in problem questions. I hope that's been helpful. Again, the only thing to do with problem questions to get good at them is to practice them, but I also would advise trying to practice writing them, because I think that's a good way to try and help you identify issues when you come to looking at a problem question. Again, this is a very much a public law focused video, but the principles are transferable across modules. And if you can nail your problem question technique early on, that's going to stand you in good stead as you move throughout your degree. So I hope this has been helpful. Thank you.